Hello, this is Attorney Brian Pendergraft with the Pendergraft firm, and I'm a licensed attorney in both Maryland and the District of Columbia. And the question for today's video is, can a tenant leave before their lease agreement expires in Maryland? Most leases do not permit tenants to leave before their lease term expires. Some tenants, or even landlords, are under the impression that they can unilaterally modify the terms of a written lease agreement because of how they feel. For example, a landlord may feel that they can ask a tenant to leave the property even though they are only 1 month into their 2-year lease. But that said, that is not how contract law works. Contract law functions based on what's written in the contract and not on our feelings. So the law will function based on what is written in the lease. So the lease term says that it's for 2 years, then the term is for 2 years. For that reason, tenants generally cannot leave before the expiration of the lease term. Be sure to check your lease agreement to see if there are any special terms or clauses that permit the early termination of the lease by a tenant without penalty. Although they are rare, it is possible. If a property is uninhabitable, then a tenant may be justified in leaving the property early. So if a property is uninhabitable, destroyed, condemned, and it's not the fault of the tenant, then the tenant can very well be justified in ending their lease early. For example, if a tenant does not have access to heat during the frigid winter season, then it may be justified to leave the property early. As a general rule, a tenant's first line of defense is to file an escrow action to pressure the landlord to fix the issues with the property. If the issues cannot be fixed, then a judge may order the termination of the lease. That said, some tenants are in situations so dire that they may be justified in abandoning the property due to how bad the situation is that they were in. The legal term for voluntary leaving because the conditions were so extremely unhealthy is called a constructive eviction. This means that the landlord should be treated as if they illegally evicted the tenant due to their failures to uphold their landlord responsibilities. Victims of domestic violence or abuse can end their leases early. They are required to give their landlord a copy of their protective order, a peace order, or a report from a qualified third party, such as a medical professional or social worker. They can give their landlord up to 30 days notice and are required to pay the rent until their vacate date. If the tenant does not leave after the vacate date, then the landlord can sue the tenant for holding over or continue the remaining lease term. Landlords can always consent to let the tenants out of their lease early. Modifications such as this should always be done in writing, because if it's oral, then a party can deny that a modification was ever made. And if it wasn't in writing, then they would actually be in a stronger position because of the statute of frauds. The way that works is that real estate contracts should be in writing, and if it's not in writing, the assumption is that the deal never actually happened. So both parties should protect themselves to make sure that the modifications of the lease terms are in writing, and that will protect both of them. Lastly, a lease term may be terminated early by a tenant if the lease terms permit it. Most written lease agreements do not allow tenants to terminate their leases early. Some may allow for it if a tenant agrees to pay a penalty fee. Be sure to check your lease terms to see if this is allowed. Thanks for watching this episode of the Ask Attorney P series. Again, my name is Brian Pendergraft, and my contact information is on the screen if you would like a landlord-tenant attorney that's pretty dope. Thanks for watching.